Welcome, everybody. Good afternoon. I'm delighted to welcome you to the second Rappaport Forum of 2025. In fact, the second Rappaport Forum in less than a month. As many of you know, the forum was created in 2020 to promote and model full, vigorous, and civil discourse on complex and challenging issues facing our community, our nation, and our world. Funded by the Phyllis and Jerome Lyle Rappaport Foundation, the forum honors its namesake, Jerry Rappaport, who has a 1L here, back in 1946, established the original HLS Forum. I want to once again thank the Rappaport Foundation for supporting this vital effort, as Jerry Rappaport once put it, to, quote, model a process that is core to our democracy. I also want to recognize and thank Bernie and Janet Asurkoff, Janelle Joffe, Sean Harrigan, and Tim Medlock and Jim Siegel. I'm not sure all of them are here today, but most of those people are here today, so thank you very much for joining us. I will introduce our moderator and then get out of the way, and our moderator is the amazing Susan Davies. Susan most recently served in the U.S. Department of Justice Office of Legal Policy. Before that, she served as the Joseph Story Senior Lecturer in Law here at Harvard Law School, teaching our 1L course. I'm a common law guy, and a variety of seminars for 9 years while also practicing at Kirkland and Ellis in DC. Previously, she served as Deputy White House Counsel to President Obama, General Counsel to the Senate Judiciary Committee, and Associate White House Counsel to President Clinton. She earned her BS cum laude from Yale and a JD with honors from the University of Chicago Law School, where she was also comments editor of the University of Chicago Law Review. After law school, she clerked for an obscure circuit court judge named Stephen Breyer, and then for U.S. Supreme Court Justice Anthony Kennedy. Susan is a much beloved legal practitioner, professor, and friend. We have missed her combination of experience and expertise, as well as wisdom, warmth, and wit. With her background of service at the highest reaches of all three branches of the federal government and as a longtime teacher here, I'm sure you'll agree that we could not have a better guide to the question of, does the law provide for a unitary executive? Finally, let me thank our panelists, Aditya Bamzai, the Martha Lubin, Karsh, and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia School of Law, and Peter Shane, a distinguished scholar in residence at my old stomping ground, the New York University School of Law. And thanks to all of the faculty and staff here who make the Rappaport Forum and many other events across the year and across the campus happen. Please show your appreciation for Professors Molly Brady, Glenn Cohen, and Noah Feldman, as well as our Rappaport Fellow, Isaiah Ogren, and for my colleagues in the Dean's Office, Liberty Keneally, and Catherine Cronin. Thanks, everyone. With that, I will turn it over to Susan.
It is a pleasure and a privilege, and I share the gratitude that the Dean expressed to the Rappaport Foundation for creating and for the Harvard partners for nurturing this kind of conversation and these kinds of moments in this place. So I am particularly privileged to be here with two such knowledgeable participants in the ongoing conversation about the powers of the presidency. And in the present moment, without being clever or coy, I will say these conversations take on a salience that we have not experienced as a nation in some time. I would also want to let people know that they are co-authors, that Professor Shane has written a couple books on the contemporary presidency and is indeed a co-author on the only casebook entirely focused on separation of powers. What I have learned in talking with these two in preparing for this day is that they are both alums of the Office of Legal Counsel at the Department of Justice, and that I clearly missed a beat somewhere. You will see it, perhaps to my shame today, in not having spent some time in that office. So the youth among you, I encourage you to consider that as you go forward. So here we are, delighted and ready to address the question, does the law, presumably the Constitution, require a unitary executive? The first short and easy answer is yes, it does. I checked. Articles 2, Section 1 of the Constitution says that the executive power shall be vested in a President of the United States, a single rather than a plural executive. And that, to repeat what many of you know, but in case you don't, that was much of the conversation when the Constitution was being drafted, fearful of a king, worried about the consolidation of power. Should we as a nation have a single person as the executive branch, or should we have a committee? Founders opted for one and opted for a constitution that has, as we all know, many structures and modes for limiting the power of branches, for checking and balancing the power of these three branches as against each other. So what matters today generally, and certainly I think for purposes of this conversation, is what the unitary nature of the presidency means in terms of power, and in particular, in terms of the power of the president to supervise the operations of the agencies that Congress has created by statute. That supervision is manifested most starkly in the president's authority to fire the leadership of these agencies. There is no supervision like sacking somebody, after all. So we will begin by asking Professor Bamzai, and I should tell you, I flipped a coin to see who would make the opening argument and who would make the rebuttal. Professor Bamzai, I don't know whether you won or lost that toss, but he's going to make the case for a strong version of the president's power to fire agency leadership. And Professor Shane is going to reply with a case for more congressional restraints on the president's power to terminate. All yours.
Terrific. Well, thank you so much, Susan. Thanks to the organizers for including me, and thanks to all of you for coming to talk about this, to my mind, incredibly fascinating and consequential topic. So as Susan suggested, it seems to me that everybody can agree that the Constitution creates a unitary executive in one sense. At the Constitutional Convention, in fact, the question arose whether to give the executive power to a single individual who would fill the office of the president, as proposed by the Virginia Plan, or have several executives or an executive council as proposed in the New Jersey Plan. The latter notion was by no means outlandish because many states had and currently have plural executives, and some even viewed the Congress under the Articles of the Confederation as a plural executive authority. The idea of a single executive put forth in the Virginia Plan won out at the convention and made its way into our Constitution. So at least nominally, in form, there is a single executive atop the executive branch at the federal level. The question then becomes whether the Constitution means for there to be a single executive in both substance as well as in form, and if so, what the contours are of that substance, what that might be. In our modern jurisprudence, as Susan also mentioned, the question of substance has depended on whether the president has power to remove subordinate executive officers under the Constitution. To take a somewhat fanciful example, just to set the debate, imagine that our current Congress were to cleave off a portion of the executive branch, for example, let's just pick the State Department, and render its head not answerable to the president, but rather, let's say, to the Senate Majority Leader. Would that be constitutional? If your intuition is no, you're in good company because I think, notwithstanding a wavering doctrinal path, the Supreme Court's majority opinions all tend to suggest that's the answer. That answer suggests, then, that there are some implied limits on how Congress might structure executive agencies at the federal level. Where do those implied limits come from, and what are their contours? So the first clause of Article 2, as Susan mentioned, vests the executive power in a president of the United States. And then Article 2 then goes on to specify a number of additional powers and duties that the president must undertake, including, for example, the authority to appoint officers with the advice and consent of the Senate, the obligation to take care that the laws be faithfully executed, the authority to obtain opinions of principal officers, and there are others. The question has always been what that first clause, vesting executive power, whether that confers some additional authority, additional to the clauses that follow, and specifically when we're talking about the unitary executive, whether it confers some sort of removal authority. If it does, then my fanciful hypothetical that I started with about the State Department might pose some constitutional problems. If it doesn't, then my fanciful hypothetical seems just fine. So the meaning of the executive power vesting clause was much mooted in the early days of the federal government. Indeed, literally everyone who had an opinion on law seems to have had an opinion on the president's authority to control the executive branch. You can find treatments of this issue from legal luminaries ranging from Alexander Hamilton, John Marshall, Daniel Webster, James Kent, Joseph Story, Benjamin Curtis, the dissenter in Dred Scott, who's then the lawyer for Andrew Johnson at his impeachment trial, among many others. That is in part why the issue remains endlessly absorbing to this day, and why, it would take me an hour really to cover much of the historical materials. I'm glad that Susan has allocated that amount of time to me for the next bit. No, I will just truly could not do justice to the various nuances to the history of this question in the short time available. So briefly, the contours are that the very first debate in Congress engaged in over the meaning of the Constitution was about who controlled the executive branch and how. The debate arose because there was a draft bill that contained language granting the president authority to remove the heads of the Departments of Foreign Affairs, War, and the Treasury, and that prompted a dispute over where the Constitution lodges a power to remove, if at all. Some, like James Madison, one of the authors of the Virginia Plan, argued that the executive power vesting clause confers a power to remove on the president, which Congress cannot modify. Others argued that because the president appoints with the advice and consent of the Senate, the president can only remove with the advice and consent of the Senate. And still others argued that the Constitution was silent on the question, which left the entire matter, punted the issue to the hands of future Congresses. Scholars continue to debate the import of this early debate. It's called the Decision of 1789. But one aspect of it is undeniable, and that's that it was a closed debate. There was a tie vote in the Senate on this bill that had to be broken by Vice President John Adams, who adhered to the perspective that the executive power vesting clause conferred removal authority on the president. The question then arose with ferocity during the Jefferson administration. This was the move from the Federalists to the Jeffersonians. Issues related to the justices of the peace in the District of Columbia made their way to the Supreme Court in a case you might have heard of, Marbury versus Madison, and to the DC Circuit Court in United States versus Moore. Again, with equal ferocity when Andrew Jackson dismissed the Secretary of the Treasury to initiate a funds transfer to weaken the power of the Second Bank of the United States. And with even more ferocity when Congress impeached and almost removed President Andrew Johnson for seeking to replace the Secretary of War, Edwin Stanton, during Reconstruction. The very last of these episodes was based on a statute known as the Tenure of Office Act, which was enacted in 1867 to limit Johnson's authority to remove civil officers without the Senate's advice and consent. And despite presidential objections, that statute remained on the books for 2 decades until Congress repealed it. And then the very same year, Congress created this Interstate Commerce Commission, which is often thought to be the first real independent agency, subjecting its members to removal for inefficiency, neglect of duty, and malfeasance in office. The following years saw the creation of other agencies subject to similar for-cause style removal restrictions, with the next major one being the Federal Reserve in 1913 and the Federal Trade Commission following shortly thereafter in 1914. What to make of all this? Well, so one perspective, which I tend to agree with, is to say that the better interpretation of the Constitution acknowledges a presidential authority to remove that Congress cannot take away by statute. That this was the best interpretation of the text in early debates, and it was the prevailing practice until about the Civil War, at which point the Tenure of Office Act interrupted the general approach, that then the good cause removal restrictions enacted after the Civil War posed their own problems, for sure, but cannot be understood to have displaced the traditional perspective on allocation of the removal power. That's the view that's expressed by Chief Justice Taft in his opinion in Myers versus United States, which was decided in 1926, and Chief Justice Roberts in recent cases. Another approach is to dispute this narrative and offer complications, and again, to be sure, I have not been able to get into every nuance here, and to say that perhaps for additional policy, prudential reasons, the history should matter less, practical concerns should matter more. That's the view expressed by Justice Kagan in her recent dissent in Selah Law. Let me wrap up by stepping back from these particulars and giving a perspective on jurisprudence in this debate. First, I think all can agree that this was a contested question around the time of the Constitution's adoption. People debated removal vigorously. One might then ask what role early debate and dispute should play in settling the meaning of the Constitution. Indeed, some might suggest that early debate itself precludes giving the executive power vesting clause a settled meaning. I'm disinclined to take that general jurisprudential view because I believe certain statutes, such as, for instance, some parts of the statutes known as the Alien and Sedition Acts, were unconstitutional, even though they received majority support in the 18th century. Thus, I would say that the mere fact that an issue is disputed does not necessarily mean that the Constitution lacks meaning on a particular question. History in this fashion can provide the contours of the debate, but judgment too must be used to decide which legal positions were stronger and which weaker. Second, on occasion, some participants in the modern debates couple their perspective on these historical debates with a thumb on the scale in favor of less judicial involvement in deciding constitutional questions, what might be described as a Thayerian view of constitutional disputes generally. I take seriously this jurisprudential perspective, but its application in this instance is debatable, in my view. For example, and now we get to like the recent issues and controversies, recent currently pending cases, they have witnessed injunctions and related remedies issued against the executive branch to keep certain officials in place, which will require constant monitoring and intervention into executive branch practices by any supervising judge. Leaving to one side the important question whether these remedies are appropriate, the efficacy of removal restrictions on the question of who controls the government appears to depend on just these remedies. And if so, as we can see, the actual implementation of removal restrictions would require constant supervision of the executive branch by the third branch of government. These are just a few of the many interesting and consequential issues that we could discuss about this topic. I look forward to your questions.
Thank you. I look forward to your answers. Professor Shane.
Thank you. I'd also like to thank the organizers for the invitation to be here. Thank Susan for the introduction, and thank Aditya for his companionship here. I have to start off by saying, and I've told this story to others, I had the privilege of visiting here in the year that this building was opened, and to acclimate people to where the various administrative offices were now located. There was a chocolate tour day in which you could get quite an elaborate truffle. You had like a dance card of the offices to check off, and if you went, from the registrar's office, you got, I don't know, a cherry cream, whatever's in the Beatles song, and that's my memory of us. And so the fact that you have to attend this or volunteer to attend this and are not getting a high-end truffle, I think, is something you should talk to the interim dean about. The second thing I would say is, it was also mentioned that both Aditya and I are alums of the Office of Legal Counsel at the Justice Department. There's been a kind of renaissance of separation of powers scholarship since the late 70s. And I had thought that we could thank Richard Nixon for it. It's been suggested that the casebook on separation of powers I co-author could have been dedicated to him. Hal Bruff, the other author, once said, we should just say, we want to thank Richard Nixon, without whom this book would have been a pamphlet. But the thing about the Office of Legal Counsel is that, I don't know, 8 years ago or so, another colleague of mine, Chris Walker, who's now at Michigan, but we were both at Ohio State at the time, decided to make a count of how many people in the legal academy were alums of the Office of Legal Counsel. And at that point, and this is, quite a while ago, the number was over 80. So the institutional reason, I think in many ways, for this renaissance is not just that these questions have become more and more salient, but because a lot of people with experience in dealing with these questions and as kind of practical lawyers have found their way into the academy. And I know that, one of the reasons that, one of the sort of motivating impetus, whatever the plural of impetus is, for the Rappaport Forum is to demonstrate the capacity of people who disagree to interact civilly. But I want to say, you're probably all under the impression that the United States is divided in between polarized parties, Republicans and Democrats. No, it's divided between people who are fascinated by the appointments clause and people who are not. And Aditya and I are members of the former party, so that explains a great deal. There's a lot of what was just said that I agree with, but I do have 4 difficulties with this supposedly historically based strong view of the unitary executive, and I'll just try to go through them quickly. Problem 1 is, I think it is, the issue before us is the president's relationship to the administrative state, to the bureaucracy, to this civil service. In 2025, when the United States has a particular role in the world, an economy of a particular size, facing challenges in which the federal government is supposed to make a particular level of response, asking, we have a text of the Constitution. I want to talk about that in a moment. But the idea that our binding guide to the president's relationship to that administrative state in 2025 should be what people envisioned George Washington's relationship would be to a federal government probably smaller than the smallest cabinet department today. Well, I've discussed this with, so I live in Brooklyn now. I do a lot of my socializing at the local dog park. I've explained this problem to many of my fellow dog owners, and the usual response is, and I'll just quote, I'm not using this language, I'll just quote them, that's nuts. We have a civil service today about the same population as the entire population of the United States in 1787. Thinking about the president's relationship to that group of people as being bound by what people thought George Washington would be doing for a few thousand folks back in the old days. It's not that they wouldn't be concerned about the same things. There would be questions of values, things that they would want to achieve that we would care about, but in a highly particularistic way, just seems odd. The text. I think the text of the Constitution is much easier to fit with a case called Humphrey's Executive, the case that upheld the constitutionality of the Federal Trade Commission, than it is with Silo law and the cases that go for the kind of strong version of the unitary presidency. Why do I say that? So the premises of the unitary executive theory, which the Supreme Court has now repeated on a number of occasions under the Roberts Court. Number 1, we have a one-person branch of government. The president is a one-person branch of government, we're told. And, to quote the late Justice Scalia, in the president was vested not some of the executive power, but all of the executive power. Both of those things might be plausible if you stop reading the Constitution after the first sentence of Article 2. But if you go on to Section 2 of Article 2, you find that a couple of executive powers are already divided up explicitly between the president and the Senate, the appointments power, the treaty-making power. So at most, the first sentence could mean in the president is vested all of the executive power, not vested elsewhere. Could be vested explicitly, could be vested implicitly, could be shared. But it can't mean all once you get past the first paragraph. So what about this one-person branch? Well, one of the powers that the president has is the power to seek the opinions in writing of the heads of the executive departments about the duties that they have been assigned. Executive departments kind of sounds like part of the executive branch, constitutionally. And these folks have been assigned duties. Now, I'm going to draw an inference that we're talking about the duties assigned by Congress. It wouldn't make sense to say, not only does the president have the power to assign duties to whoever he wants, he can demand that they respond in writing. with regard to their opinions, that wouldn't make sense. The duties that refers to must be duties imposed by Congress. The Trump administration is fond of saying, and this is picking up from the Supreme Court, that these agencies are acting on behalf of the president. They are not. They're acting on behalf of Congress. The president's duty is to take care that the laws be faithfully executed, not to execute them, but to make sure that those who execute them are doing it faithfully. That's what the text means. If you're looking for the word all, Justice Scalia, I'll tell you where to find it. It's in Article 1, Section 8, the last clause, the necessary and proper clause, that gives Congress the power to enact all laws. That's the first time it shows up. All laws necessary and proper to carrying into execution all powers vested by the Constitution in any department or officer thereof. That has a kind of comprehensiveness feel to me. So that's the text. As for the founding period, and we could talk more about this, I do think, by and large, the originalists who have described the period as if it embraced a strong version of the unitary executive are mispresenting the founding period. I don't believe that the folks who ratified the Constitution had been given the impression that there was any consensus that vesting the executive power in the president would give the president any sort of comprehensive removal power, much less this stronger version of the unitary executive. But we could talk about more details of that. My last problem is that the unitary executive idea is susceptible to metastasize. I wrote a book in 2009 about this problem, which I called Madison's Nightmare. And I wrote another book that came out in 2022, and I was going to call it Madison's Nightmare 2, I Told You So. If there's a movie version, we may go with that. Because almost everything that I thought of as in the realm of the hypothetical in 2009, we're now living out in real time. Adity's work, I think, is very careful. And even though we may disagree on the conclusion about a particular power, I think I'm correct in saying that his approach is to look at Article 2 with regard to specific powers. Is there a specific power to remove? Is there a specific power to do X, Y, or Z? And that question by itself doesn't necessarily entail this broad, comprehensive power of the president to control everything. The president could have a power to remove that doesn't imply, for example, a power to redesign agencies, to move functions from agency to agency, or to impound funds or anything. It doesn't have to happen. But psychologically, if you say to the president, you can fire anybody, you give that idea to a president whose legal understanding may not be nuanced, and lawyers eager to facilitate that president's every move, the move from I can fire everybody to I can tell everybody what to do, in fact, the fact that they can do stuff is not just because Congress gave them license to do it, it's because I have not taken over the function myself. So I'm letting them do it. Now they owe as much to me or more than they do to Congress. As I said, in 2009, I would have said, this is a hypothetical, and people would say, oh, that's never going to happen. I rest my case.
Okay, following up on the enticing chance to say necessary and proper several times here. The hallmark of independent agencies is protection, is for-cause removal protections. But that is presumably an expression by Congress that it is necessary and proper for whatever this agency they created, whatever its responsibilities and obligations are, the good that it's going to do in the world, that this agency needs some insulation. and often some stability, some expertise. That this agency has been created and needs this cushion, and for-cause removal is there to protect those characteristics of the agency. I think we also associate with independent agencies a bunch of other, more or less, bunch of other characteristics. Multi-member rather than single heads, staggered terms, terms that don't run in a 4-year cycle like somebody else's, bipartisan membership on these boards, sometimes independent litigating authority, sometimes budget authority that isn't about appropriations but about fees. And these features that we associate with independent agencies are presumably also what Congress has deemed necessary and proper for these agencies to do the work that Congress has assigned to them as it structures the executive branch. And these other features are important to courts. The courts, even in the few very exciting and more recent cases about the president's removal authority, don't just say for cause or at will, the whim of the president or a constrained whim of the president. Seal of law, the exceptions that the court recognized there looked a lot like multi-member expert agency, Humphrey's executor, inferior officer with limited powers, Morrison versus Olson. The constitutional objection to the CFPB and the majority there seems to have been, at least on one understanding, that it lacked historical precedent. This one single-headed independent agency, it didn't fit with what we as a nation had come over since 1887, come to recognize as the features of an independent agency that Congress, was necessary and proper, had created these beasts. So what role have those characteristics of an independent agency, presumably reflecting congressional concern about insulation, about stability, about expertise, what role have they played in the jurisprudence thus far? And what role do you think, I'll give this to you, Professor Bamzai, first, going forward, they might or might not play? Are they necessary to consider, necessary in the lowercase, not necessary and proper, and not unnecessary and improper, but are they appropriate, useful, meaningful to consider by the court in the status of this relationship between the president and the agencies?
Yeah, well, so a really deep question, and I think it's deep because it so happens that many of these agencies that were given for cause protection over the course of a century happened to also be multi-member, have these staggered terms, have these other attributes that Susan is pointing to. And I mean, I think what explains it is that perhaps in the policy, political science, or public administration spheres, people thought this was how we would obtain good administration. This is the way in which to have a well-functioning executive branch, to have these multi-member boards with staggered terms, some sort of bipartisanship requirement. And you know, in terms of public administration, of course, people can be the judge of whether that worked or did not. And that aspect of the kind of happenstance of the boards being created during that era, it does filter into the doctrine because we end up in seal of law with the court confronting not that multi-member board, but rather a single-headed agency. And I think the reductio that the court, was thinking about in that moment was, well, if we bless this statute involving the head of the CFPB, what about the Secretary of the Treasury? Or if we extend the implications, what about like the Secretary of State in my hypothetical? Where's the stopping point? So there's language in the court's recent opinions that suggests that this distinction matters, the multi-member versus single-headedness. And in terms of, part of your question was asking me to predict how that'll play out in the future. And believe me, if I could predict Supreme Court cases, I would be in a much better paying job than I am right now. So what I think I would leave you with is that there's language in the seal of law, the court's most recent opinions, that seems to downplay that as well. So there's language that suggests, oh, the way in which this case is different from earlier cases is the multi-member aspect. But honestly, in all candor, there's language as well that says, oh, and here's some other ways in which we could distinguish the Humphreys executor or Morrison versus Olson opinions. So in terms of actual prediction, I don't know where that leads us. To my mind, the multi-member versus single head issue. And I'd be curious about Peter's thoughts on this. Could lend itself, it's sort of functional, frankly. It's not like baked in to any of the debates in Article 2, but it's functional in that Justice Kavanaugh, when he was a judge on the DC Circuit, said, look, all these multi-member boards, they're going to flip over in a year or so. So really, there's like a lag time with presidential elections. Like they get control over these boards within a year. Whereas with the CFPB director with a 5-year term and removal protections, you could go a whole presidential term without controlling the head of the CFPB. And to just make it practical, Elizabeth Warren could have been elected president and just not had ability to control the CFPB during her presidential term, which seemed odd to people. So that's my set of thoughts on that question, and I'd be curious about Peter's.
Yeah. So it is a deep question. It implicates a lot of things. And I would just say it's important, I think, for purposes of our discussion, to underscore that we are not actually debating the wisdom of independent agencies per se. We're debating whether the decision to create independent agencies is a decision that Congress should be allowed to pursue. I think the factors that you mentioned, Susan, are factors that have caused or helped induce the court's deference back in the day to the idea that Congress should be able to create these agencies. But it would be hard to look at the list of all of the administrative agencies in the government and come up with kind of a principled explanation for why Congress, over a period of 140 years, decided these agencies should be independent and others not. The decision in the real world is often made in part based upon the politics of the given moment. You know, setting railroad rates was going to be happily part of the Department of the Interior until a railroad lawyer named Benjamin Harrison got elected president. And then suddenly the idea of an independent agency looked pretty good. Why do we have an independent Consumer Product Safety Commission, but not an independent Environmental Protection Agency? Both are, you know, influenced by science, or ought to be, engineering, economics. Oh, Richard Nixon was willing to have an independent Consumer Product Safety Commission. He was not willing to have an independent Environmental Protection Agency, and the Democratic Congress needed the Republican president to go along with what the EPA would be. I do think, in terms of Humphrey's executor itself, it's interesting to reflect on the fact. So we have this unanimous decision in 1935. 6 members of the court had been on the Myers court that just 9 years earlier had done what was explained, which is they'd said that Myers, as postmaster, had to be dischargeable at the will of the president. But you have this coalition, it's a unanimous decision, 6 members of the prior court, a coalition that embraced not only some of the most distinguished members of the court ever, but also ardent New Dealers and all apocalyptically related horsemen. They were all there, and they all agreed on this. And it was at the time taken to be a relatively conservative position, as opposed to the more activist desire of the Roosevelt administration. Suddenly, we see the unitary executive flowering in the early 1980s once the Reagan administration comes forward. And one might ask, why did this become the more conservative position? I don't think, well, I'm borrowing here from the political science work of William Howell and Terry Moe, who point out that, if you start from the proposition that every president wants to be thought great, that's not just the current president. Every president wants to be thought that they've played an important role in history. If you look at modern presidents on the progressive side, and I would include Eisenhower among them, and even Nixon in a sense, they don't have to invent new constitutional arguments to fulfill their campaign promises. They just have to interpret modern statutes in a fairly capacious way. Congress has enacted a lot of statutes that allow the federal government to attack a lot of problems. And if they overstep, the courts call them back. It just looks like normal legal stuff. If you are elected with the agenda of destabilizing or incapacitating or drastically reducing the capacity of the federal government to do any of the things it's been assigned, there's not going to be a statute that obviously gives you the authority for that. And I think it was the hope, I'm not saying this is true of the scholars who are working in this area, but I think a lot of the political push behind the theory came from folks who realized that without a stronger constitutional presidency, electing a president who wanted to reduce the bureaucracy was not going to be able to produce that result.
Okay, well, if a president wants to reduce bureaucracy, this is, take Professor Bamzai's view that the president can fire principal officers at will. Do I do a disservice to your view?
No.
Okay, great. What about inferior officers? What about employees? What about my former paralegals? I got
Yeah,
a couple
no.
of ex-interns sitting over there.
It's a great question, and I think that there's a way to answer it within the black letter law, which is that the court has bracketed that there might be removal provisions for inferior officers that are appropriate, as well as not really said anything about employees, a distinction that we haven't really talked about, but we could talk more about. Now, I have looked into this a little bit, and it turns out that this distinction between differential treatment for principal and inferior officers was long debated. That in fact, you could go back and find like aspects of the decision of 1789 where people say that this is the rule for principal officers and not the rule for inferior officers. Justice Story makes a similar allusion in his commentaries. And there's a debate about it when the civil service laws are enacted in the 1880s. So again, taking my own perspective, I think that there's a at least principled reason by which you could distinguish between the two. Having said that, I would say that there are ways in which one could like come up with creative workarounds to my framework, which I would then balk at. So for example, what if there was one principal officer who was, just the principal officer for the entire federal government, the chief secretary, and then all the departments were underneath that principal officer. I would then have some reservations about that type of framework. But hopefully that, answers the question, which is that I think there's a way in which a principal distinction could be made, not just one within the black letter.
Okay, you are hopeful about that answer, but I am persistent about the question. If the notion behind at-will firing authority over all principal officers exists in a president, that the president needs to, and is granted by the Constitution, the authority to control all that goes on in the executive branch, why could that president not fire, in addition to the Attorney General, also the head of the Civil Division or my paralegal? I mean, on the theory that if you
Right.
accept the theory, president gets to say what happens in the executive branch. By the way, my paralegal was wonderful and should not have been fired by anybody.
Yeah.
Beatrice, if you're watching, that's.
So to be clear, there were people who took that position as well. And I think that what you're asking is that if in fact that is the justification for the general position, then does it have to be taken to its logical conclusions? So that would be the slippery slope on one side. And then I've asked the slippery slope on the other side, which is what about the protection that you could give to the Department of State? I think that what you might be probing is if in fact there is some sort of middle ground position, is it justifiable? And it seems to me to be justifiable and sensible, but then it would not depend on just the, everybody depends on the president's style rationale that you just articulated.
So I think black letter law, insofar as I understand it, I think does permit the middle ground because the ordinary rule is that the power of removal follows the power of appointment. So actually, I think it would be, and if Aditya is right about, all principal officers are removable at will, then that helps to account for a puzzling distinction that Chief Justice Taft made in Myers itself, where he says that there's a distinction in the removability of inferior officers depending on whether or not Congress has vested their appointment in the president or the head of a department. Congress has that option under Article 2, and he says, if Congress has made the decision that somebody can be appointed by the head of a department, then that's where the power of removal lies. If you want to have the hierarchical pyramid that Chief Justice Roberts envisions, you could just say, okay, yes, heads of departments, they're the only ones who can fire their underlings. If they're not firing the underlings the president wants fired, the president can fire them. And that would sort of be kind of consistent with that.
Okay, so these inferior officers and the employees, the underlings, as you call them, are presumably executing the law, right? So the take care clause says that the president charges the president to take care that the laws be faithfully executed, and that sentence construction suggests the recognition that the president is not personally executing all the laws, but is taking care that those laws be executed in large part by other people. So if the president is overseeing the faithful execution of the laws by others, what work does faithfully do in this clause? What does faithfully mean for both the POTUS and the transposition to the underlings' obligations of faithfulness?
So I should say I've written an article called Faithful Non-Execution.
I know.
Because I think what you're asking is an important question. Now, we have, even in, I think, in 1789, there was no assumption that every law would be implemented to the maximum extent possible, that there would be no discretion ever shown with regard to how a statute would be brought to bear on the public. And of course, this is, exponentially less plausible today. Despite, we're seeing, for example, in the immigration context, where, this president, current president wants to ramp up, the comprehensiveness of enforcement, that turns out not to be plausible within, the resources available. And so there's always going to be room for discretion. The question is, what principles are going to guide that discretion? I would argue that if there is a case to be made, and when I say a case, I don't necessarily mean a justiciable case. I don't think a justiciable controversy is ever likely to be presented that says, well, what the president has done is unconstitutional because he executed the law but not faithfully. I doubt that that text is going to be the basis for that. I could be wrong. But if an argument could be made that what the president is doing is consistent with the overall effectiveness of the implementation of the particular statute or the complex of statutes of which it is a part, then I think that's being faithful. You're being mindful of what Congress wanted to happen, and you're trying to act in a manner that's consistent with those objectives. I think it is not faithful execution. Well, there are obvious cases where, out and out corruption would not be faithful execution. But I also think, imposing upon the enforcement regime a set of values plainly antagonistic to the statutory design is also subject to challenge. That's probably is. And this, has implications for how much discretion the executive branch has in terms of allocating resources. Decide, if a president says, I want to see more white-collar crime prosecuted, or I want to see, more emphasis on drug crimes, or I want to see more emphasis on, antitrust actions, that general focus on, well, you were head of the Office of Legal Policy, the focus on legal policy, I think, is, nobody doubts the legitimacy of it. It's when you get down to the president saying, I want you to go after these people because they made my life hard, that you begin to doubt the fidelity to law.
I think in terms of the big picture legal perspective, I mostly agree, which is that when it comes to under enforcement or prosecutorial discretion under statute, that can be, depending on the circumstances, faithful execution. And that can also be heavily politically disputed. I doubt whether, and we haven't seen a case where the Supreme Court has adopted the perspective that that's justiciable, and somebody could just bring a lawsuit and say, you're under enforcing these laws, that's not faithful execution. So I too share that general perspective.
I hope the Rappaport Foundation appreciates that little mutual hug. And I'm mindful of the time, and that there are probably, I have a whole folder full of questions, but there are probably better questions in these chairs out here. There is a microphone in the back. There's a hand over there. Why is the first person who volunteers always maximally far from the person with the microphone?
Because they didn't want to be asked questions. They just want to pose the question.
Thank you all for coming. I have a question, taking a historical approach to analyzing the constitutionality of independent agencies. I'm wondering what your views are on the argument that the original sinking fund of 1790 that had non-executive government officials as part of it, whether or not that suggests that there may be some scope for at least kind of semi-independent executive bodies. Thanks.
Yeah, no, so it's an interesting entity, and for those who don't know, this is an entity that's proposed by Alexander Hamilton to address the nation's assumption of these various debts. And the entity, correct me if I'm wrong about some of the details, it has the Chief Justice, the Vice President, and then 3 cabinet officers who are members. And so the Supreme Court, I want to say in Collins versus Yellen, addresses the topic in like a footnote, and they say, well, it was majority controlled by the cabinet in any event. I have that perspective as well as one other, which is the following. I do not believe, and I welcome Peter's correction on this, that in the various debates, again, this is an issue that's hotly debated during the course of the 19th century, people say, aha, the Sinking Fund Commission, that means anything goes. And that the Tenure of Office Act is constitutional, or Andrew Jackson's removal of the Treasury Secretary is problematic. So my general take and read on those debates is that they had a perspective on the Sinking Fund Commission. It actually was about a particular type of function. And in fact, Alexander Hamilton is probably modeling the Chief Justice's inclusion based on British practice, where judicial officers would have been on a comparable commission. And Hamilton embraces ultimately the sort of unitary reading of the decision of 1789. So the way I would harmonize the set of precedents is by saying there is in fact that precedent, which I take seriously, but it stands for a narrower proposition than the broader proposition that all these agencies could fit within that exception.
A couple of things come to mind. One is, if you're looking for debates that haven't happened, one of the most interesting debates that hadn't happened was any debate at the Philadelphia Convention about removal power. It's not discussed. There's no indication that this was an issue at any of the ratifying conventions. In terms of the Sinking Fund Commission, again, I think you got the details right. I would just say, because you mentioned both Treasury and state as, could Congress possibly insulate the heads? So I think the argument with regard to the State Department has nothing to do with a general removal power. It has to do with the fact that the Secretary of State sort of inexorably assists the President in performing duties that are explicitly in Article 2 as presidential functions. I think the President, if the President is charged with negotiating treaties, he's entitled to complete control over the person who helps in the negotiation of treaties. With regard to the Treasury Department, and again, this goes back to my point that I think the founding period is not being fully appreciated. The vesting clause language, faithful execution language appears in a lot of state constitutions, both before 1787 and in the period right after. So we can sort of look and see what folks thought that language meant, which I think might be a pretty good guide to what voters, the few who were allowed to actually vote on ratification, thought they were buying into when they voted for the Constitution. And a number of those constitutions had treasurers who were appointed by the state legislature, even though the executive power was vested in the president. I think that, and Alexander Hamilton, functioned in the first Congress pretty much as the equivalent of their chairman of Ways and Means. I mean, they relied entirely on him for advice about the fisc, the federal, public funding. So I think, the historical case for insulating the Secretary of the Treasury from at-will removal is not frivolous. Secretary of State, I think, is different, but I think in each case, we could look and see how what the person is doing relates to the functions that are explicitly presidential in Article 2.
Could I add just one thing on that? Which is,
Yes.
so there is in fact a provision in the Constitution that remains in there until one of the very last drafts for an independent treasurer, and it's removed ultimately. So there is a debate about this that occurs in the Constitutional Convention. I'll just stop right there because I know we're running out of time.
That's fascinating. We got to talk more about that.
Yeah, we're having lunch. Are there any other questions?
Hello, thank you so much for speaking with us today. I'm curious, I think there's been news recently in the legal community of folks worried about the Unitary executive being extended to the Fed and nervousness around Trump having the ability to remove there. So would love to just hear your thoughts on the Fed and if there's a way to constitutionally distinguish the Fed from other independent agencies.
I would just say I think it is because of anxiety about the Fed that is the strongest practical reason why the court has not overturned Humphrey's executors so far, despite their thirst to do so. I know I have seen, there's an article in Southern California, somebody has tried to lay out a case for distinguishing the Fed, but I didn't find it persuasive. I don't know if you...
Well, so as I'm happy that you're not referring to my article because I did not publish in the Southern California Law Review. I wrote something on this, and this is some other article that Peter did not find persuasive. Well, here's one possible argument, and people can decide whether they find it persuasive or not. One of the other entities that is created in order to address the nation's fiscal problems in the early republic is the National Bank, the Bank of the United States. And the Bank of the United States created as is it public or is it private? There are in fact debates about this in the early era. And then as you all know, the charter's allowed to lapse. It's recreated as the second Bank of the United States. That's the Jacksonian era, and they have a big fight about it. So there were these entities that served a function that were private. And when the Fed is being debated and almost created in about 1912, 1913, it would have been like the second kind of major independent agency. There's a proposal to create what effectively would have been a third Bank of the United States, like a private entity. And the Fed, as you may know, is it's not actually one entity, it's like a conglomeration of different entities, some of which have this private status, some of which have a public status. And my bottom line response would be that if it's doing things that are like generally the banks of the United States, that can be conferred on entities that are given this like privatized status. Whereas if, for example, we were all of a sudden to give the Fed control of, I don't know, the CIA or something like that, there would be nothing magical about it being the Fed that would make that constitutional. It would be about the functions that the Fed is performing. So that's my instinct on that general topic.
Can I just add one quick sentence, which is I think it was in the 80s or 90s that Walter Dellinger and Jeff Powell wrote an article about how the national banks would fare if it was presented to OLC as a question today. And they said the first question we would have asked is, what makes the appointment of these people constitutional? And the fact that they couldn't be removed. So
I know we're over time, but that's a hand I can't ignore. You, yeah, your hand.
So I just wanted from an original context, why it's not obvious that rather than being a simple rule, it's a more subtle rule. I mean, Peter pointed to the opinions clause, which my students reminded me says executive departments as opposed to departments. The original great departments were explicitly denominated executive department for foreign affairs and executive department for war, but Treasury was just denominated a department. So it seems they had a sense that there are different animals on the field and the rules about controlling them might be different. There might be a reason why we've got to give that up today, kind of a Scalia-esque Boucher or Sinar lower court opinion reason. But I just wonder, originally, isn't it fair to say they just didn't think that these were all the same things?
So I don't know about that. I mean, I would respond by saying, I don't know if the title of executive department versus just department, I would put as much weight on that as, I understand, of course, we're thinking back to your groundbreaking article with Professor Sunstein from about 25 or 30 odd years ago. So I'm disinclined to say that that particular naming convention had as much weight. I think that the answer that I gave to the prior question, which did distinguish between some functions and others, does get a little bit to the heart of the question, which is, could there be some nuance here? And I think there could be. The Fed is not the only quasi-private entity, as you probably are aware. There's the Financial Regulatory Authority, or there's Horse Racing Authority, or there are other corporations. So there is room for a little bit of nuance on that topic. I think that I would have understood the Treasury Department to be within the scope of that debate that occurred in 1789.
So I guess one thing that we haven't talked about as much, but maybe implicit in what we're saying, is the subject of, what ought the role of the courts be in delineating any of this? And I just have a hard time. I mean, I think, what Professor Lessig has just said, other histories of the period point out, it's very hard to make a case that there was certain consensus around a hard principle. And in the absence of clear consensus, I mean, yes, they all knew what a 35-year-old president would be. But why should the court be taking it upon itself to second-guess Congress? It's one thing for language that we would all interpret in exactly the same way, which is probably why it's never litigated, to be enforced by the courts. It's another, I think, to second-guess the political branches who have their own tools for going back and forth, to tell them that their options are limited in the face of what is real historical uncertainty as to what the founding generation thought.
Okay. Last two words are mine. Thank you.